Hello, everyone, and welcome to today's webinar. Before we get started, I want to go over a few instructions and guidelines. This webinar will be presented in English and French with simultaneous interpretation available in both languages. To choose your preferred audio language, click on the globe icon labeled Interpretation at the bottom of your Zoom screen and select the language from the list. On mobile, tap the three dots or the More icon and tap Language Interpretation. Live closed captioning is also available. The presentation slides are available in English and French. To view your preferred language of presentation slides on desktop, go to the top of your screen and click the tab that says either English Slides or En Français. On mobile, there will be a small screen share drop-down at the top of your screen, and when you click it, it will show slide options. All participants automatically have their mics and cameras off. If you have questions for the presenters, please type them in the Q&A box. And there will be a bit of time for Q&A at the end of our presentation. The chat is now open, but it will close when the speakers begin their presentation. If you're experiencing technical difficulties, you can post those questions in the Q&A as well. There will be an evaluation form that automatically opens in your browser after the webinar has ended. A certificate of participation will be generated once you complete this evaluation. This webinar is being recorded. The recording, slides, and a resource list will be posted on the Awareness to Action or Family Violence, Family Law webinar website, as well as on the Red Flag webpage and emailed to you after the event. So we're now going to officially begin. It's such a pleasure to be here. My name is Katrina Scott. I am the Academic Director at the Center for Research and Education on Violence Against Women and Children here at Western University. Today's webinar is on Red Flag Law Awareness, Protecting Against Firearm Harm in Gender-Based Violence. We begin with a land acknowledgement. I want to acknowledge that we are learning, speaking, and hosting this virtual event on the traditional lands of the Anishinaabeg, Haudenosaunee, Lenapewauk, and Chinongtong nations. These lands are connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. Today, this land continues to be home to many Indigenous peoples from across Turtle Island. We give our deep respects to the first inhabitants of this land and recognize that an acknowledgement of Indigenous lands and sovereignty comes with a responsibility to understand the history and ongoing impacts of settler colonization. These impacts continue to be felt in disproportionate and everyday ways against Indigenous communities. We also reflect on those who came to this land involuntarily, particularly those brought to these lands because of the transatlantic slave trade and slavery. Doing a land acknowledgement at the beginning of a webinar in the area of family violence and family law is important to me for many reasons. One concerns access to justice. As we begin our conversation today, I think it's important to remember that access to a fair justice system response is not equally available to all. Indigenous peoples in Canada often face racism when trying to get help from legal system actors, and as a result, they may be justifiably more distrusting of the family court system. And as I was reminded in a conversation the other day, where you live makes a big difference in the access that you have or don't have to courts. In many rural and northern areas, courts may only sit for a few days a month. Traveling to a place where court sits more regularly may be extremely difficult. This means that access to justice, which we like to think about as equally available to all, really isn't. And I think that it's important that we take this into consideration in our conversation today. Today's webinar is being hosted as part of an ongoing series led by the Awareness to Action project in the family violence and family law area. The Awareness to Action project aims to expand trauma-informed training for gender-based violence for family law specialists, and to develop and promote standardized screening tools to guide decision-making in family violence-related custody cases, and to help professionals promote safety throughout a case. Considering firearms is certainly one of those things that needs to be considered. To learn more about the Awareness to Action project and check out its resources, please access the website links posted in the chat. You can also find out more about the Center's Red Flag Law Awareness Project. These links will also be posted in the chat. So as we begin, I'm going to introduce our speakers for today's webinar, and they're going to come on at various times during our discussion. Dr. Carolyn Fraser is a member of Ontario's Domestic Violence Death Review Committee and a recognized expert in domestic violence prevention and response. Since 2017, she has served at the Ontario Police College as the resident subject matter expert on domestic violence, coordinating and delivering specialized investigation training programs. Suzanne Zakur is the Director of Legal Affairs at the National Association of Women and the Law. She is a feminist author, researcher, and public speaker. She recently completed her doctoral degree in law at Oxford University, focusing on partner sexual violence. Heidi Rathjen graduated from École Polytechnique in Montreal in 1990 with a bachelor's degree in civil engineering. Following the December 6 massacre at her university, she chose to dedicate her career to advancing public safety rather than pursuing engineering. In 1990, she co-founded the Coalition for Gun Control and served as its executive director until shortly after the adoption of Canada's Firearm Act in 1995. She continues her advocacy in this area today. And finally, we will hear from our own Emily Tallon, who is leading our red flag awareness work at CREVAC. Emily attended law school at the University of Victoria and began her career working in the restorative justice field. In the past several years, her work has focused on understanding the experiences of family violence, of survivors of family violence navigating the family justice system, and developing resources to support with justice system navigation. So this webinar is going to be a combination of short presentations and facilitated discussion. We're going to be starting with an overview of the development, purpose, and practicalities of the recently implemented red flag laws. We'll then put these new provisions in the context of other firearm-related protections available across Canada. We'll discuss some of the challenges in getting this legislation put into action and some of the practical applications of red flag laws in family law contexts. If you are primarily interested into like a how-to guide for this new legislation, we encourage you to access resources created and published by Public Safety Canada, which is going to be in a link in a minute. And there's also a number of tip sheets available now online. And one I particularly like is one produced by the Native Women's Association of Canada. And so we're going to put that in the chat as well. But, as we will discuss, red flags are only one tool among a number of others. And it's important to consider all of them together. We're going to share some other resources as well at the end of this webinar on other means of removing firearms, But honestly, it's pretty complicated. It always makes my head spin a bit. What do you use when, under what conditions, with what time frame, and what risks? And the answers to all of those questions matter in terms of where you live, because depending on which province or territory you live in, you will have access to different means of firearm removal. For attendees in Ontario, we are working on creating some practical how-to guides, and these will be available later in 2026. Other groups are working on similar guides in other provinces. But for now, what we really encourage you to do is join us in the discussion of some of the complexities of this area, and really think about what this means for its history and for ongoing legal advocacy. What's less challenging than figuring out how to use the various provisions to remove firearms is the need to think about the relationship between firearms and domestic homicide. Some of you may have caught the webinar we did this fall, where we featured several chapters of the DVD-RC report, one of which was on firearm-related domestic homicide. And what you may remember is that in a review of domestic homicides between 2002 and 2023 in Ontario, 29% of all deaths were caused by a firearm. Cases that involved a firearm had more fatalities, and that this was a special concern in rural areas. Other international research aligns with these findings. We've had convincing evidence for over 10 years that having access to a firearm increases the odds of homicide and suicide by 3 to 4 times. And there's a recent study by Stansfields et al. That I was reading in 2021 that related in the US the prevalence of firearm dealers to the rates of intimate partner homicide. The more firearm dealers, the more intimate partner homicide. It is for these reasons that access to a firearm is a recognized risk factor on almost all standardized risk assessments for domestic violence. Yet, particularly in the family court system, I don't think we often think about firearms, even when we're thinking about safety. So, with that kind of setting of the context, I'm going to pass this over to Emily to provide a short overview of what we're trying to achieve in our red flag awareness projects. Emily, welcome.
Thank you, Katrina, and hello to everyone. We did want to start today by sharing some of what we've learned since beginning this project at CREVAC on red flag laws. In many of our conversations, we found that there is still a relatively limited understanding about what red flag laws are, how they work, and the other changes to firearm laws that were recently introduced through Bill C-21 in late 2023. Furthermore, questions remain about exactly how these new laws will fit into existing protections and other legal avenues that have the goal of protecting against firearm harm. So over the past several months, we've been working closely with communities of practice across Canada that are connected to our family violence and family law and awareness to action projects to help inform the development of resources for family legal professionals about red flag laws. And they've really provided us with some helpful insights and direction as we've worked towards developing both this webinar and also a forthcoming brief on the topic. Namely, those groups have emphasized to us the importance of education and awareness for those working in the justice system, including family legal professionals. And they've also provided us with some helpful insight on things we need to keep in mind around jurisdictional differences that might impact both how and when these red flag laws might be used. For example, civil protection orders vary quite a bit by region, and so we'll touch on that a little bit later in the webinar as well. Community of practice members also raise some important concerns and considerations to really keep in mind to ensure that these laws achieve their intended purpose to reduce harm and to enhance safety, especially for survivors of family violence and children. Some of the feedback from our communities of practice included the importance of smooth and timely implementation, limiting potentials for increased risk, considerations around effectiveness, and the added complexity of legal system navigation. And some of our speakers today will expand further on some of these considerations and concerns. We also wanted to start by providing some of the information around the context in which we saw these changes introduced through Bill C-21 in Canada. Bill C-21 included the introduction of red flag laws, which we'll speak about in a moment, and other amendments addressing firearms. Leading up to and around the time of the introduction of Bill C-21, there were several important reports and inquiries really speaking to the need for enhanced protections around firearms, especially in relation to intimate partner and family violence. The Mass Casualty Commission final report was one report that emphasized this issue. Many of you may have had a chance to look at this report. It's significant, it's substantial, and it has many important recommendations. And it also includes a specific section dedicated to firearms and gender-based violence. In the resources we'll share with you at the end of the slides, we'll direct you to the section of the report, which also includes a very helpful overview of the history of firearms regulations in Canada for anyone who might be interested. One central lesson shared in this report is that women survivors are at an increased risk when there's guns in the homes. This report examined concerns that can arise when community members see red flags but don't have access to knowledge about how and where to safely and with a sense of security report those concerns to authorities who can intervene. Individuals may also be discouraged from coming forward due to fears about how authorities might respond and the potential for negative repercussions. The report also pointed to important opportunities to strengthen Canada's firearms regime, but it also stressed the importance of preventative approaches and building processes outside of exclusively criminal and regulatory contexts to include public awareness, education, and processes to help support with safe reporting of firearms concerns. Many of the recommendations related to firearms in the Mass Casualty Commission's final report were adopted directly from the Renfrew County inquest in Ontario. Around this time, there were also several important recommendations coming out of another inquiry in Nova Scotia, the DFI, several of which focused on communication and access to information as it relates to firearms. More recently, as Katrina mentioned, the Domestic Violence Death Review Committee in Ontario, in its recently released report, dedicated a chapter to intimate partner homicide by firearm, adding to the evidence showing that firearms in the home is a significant risk factor for domestic homicide. So with some of that context and background in mind, I'd like to first turn it over to our next speaker, Dr. Carolyn Fraser, with our first question. And Carolyn, we're hoping you can tell us a little bit about the new provisions available under Bill C-21, including the red flag laws and available protections. And can you also share with us some other national level options that are available for firearms and/or license removal?
Yes, thank you, Emily. And again, I just wanted to say welcome to all the people in attendance, and thank you very much for taking an interest in this particular topic. So, I'll just start with, although these laws aren't directly related to family law, they are highly relevant to family law cases. With the work that you do and working with clients, it's inevitable that you'll have survivors of intimate partner violence or people who are actually experiencing intimate partner violence. And certainly when children are involved and when there's parental arrangements to be made and disputes over access, it certainly complicates the situation. And we know, like Emily and Katrina has already mentioned, that when there is firearms present in that situation, it greatly increases the risk for the survivor and for the children. So red flag laws is part of a broader federal strategy to combat gun violence. This is a government initiative that was initiated through Bill C-21. So what is Bill C-21? So Bill C-21 is officially titled an act to amend certain acts and to make certain consequential amendments. Firearms received royal assent on December 15th, 2023, enacting a range of firearms reforms, including national handgun freeze, the red and yellow flag laws, which we'll be talking about today, and stronger trafficking penalties. The bill introduced a new red flag law and measures to address gender-based and intimate partner violence, aiming to increase public safety by removing firearms from potentially dangerous individuals. So the overall intent and goal is for harm reduction. So what exactly are red flag laws? So it refers to two new types of orders available to any person by applying to a provincial or territorial court. These two orders are an emergency prohibition order and an emergency limitation on access order. And I will explain both in a bit of detail for you. So the emergency prohibition order is an order, it's a temporary order to remove firearms, firearm licenses for up to 30 days for someone who may be a danger to themselves or others. And just so you know that these orders are applicable to people who have mental health issues, who are if there's issues for suicidal ideation or concerns about someone's mental health and their own welfare. The hearings can be set to consider a longer term prohibition up to 5 years if there are extenuating circumstances and elevated safety risks to the victim. One of the positive or pros about this prohibition order is that any person may apply ex parte to the courts. So this is a pro in the fact that any person other than the survivor or victim who may be at risk, so a family member or support person, may go forward and apply for one of these orders. And ex parte is nice as well, is because the subject of the application or the respondent is not included in this process unless the order is actually issued by the judge. Measures are in place to protect the applicant's identity, which is also another positive. So whether in-camera hearings are used as a measure, redacted information from documents, sealed records. However, when an individual or applicant wants their identity or identifying information to be protected, they do have to apply to the courts, and the courts do have to determine whether or not it is in the best interest to protect that person's identifying information. There's no lawyer involved in these cases, which is obviously a cost saving to the applicant, and there are victim services and other community agencies that can help the applicant through this application process. The focus is on harm reduction, like we already mentioned. And there's no criminal record created in relation to this if an order is issued. Unless the order is breached by the subject, then it would be disobey court order. Now, the second type of order is the emergency limitation on access orders. So this sets rules for another person's possession or use of firearms if there is a risk that their firearms could be accessed by someone who's already under a prohibition order. So we know when couples, if they split and one moves out of the home and lives with a relative or a family, so a family member or a friend, and there's concerns for access of firearms within that particular resident or location, then this order allows to extend the protection in that regard. So again, in the criminal sense, if someone has been released on residential surety, police officers will make sure that that resident does not have firearms because we know that it poses a significant safety risk to the victim survivor. And again, it can last up to 30 days with a possible extension via prohibition order. I'll just briefly touch on the yellow flag laws just so you are aware because it was mentioned in Bill C-21. So the yellow flag laws has to do with the chief firearms officers, and the chief firearm officers they are responsible for continually monitoring firearm licenses that firearms people, sorry, if owners of firearms have. So they can temporarily suspend firearms license for up to 30 days when IPV is suspected. And these suspensions provide time to evaluate whether full revocation is required. Now, because the Chief Firearms Office is a regulatory agency, they are as good as the information they receive through police reports and through the public. So I have included on this slide the CFO contact information, a number, and an email. So if there are concerns, if anyone who owns or has a firearms license or access to firearms, then you can provide information to the chief firearms officer about the concerns that you have, and if it's in the best interest of public safety for this person not to have a firearms license or access to firearms. Also with Bill C-21, there is enhanced license ineligibility and revocation. So in April 4th of 2025, there's an automatic ineligibility for firearms licenses. So individuals on a protection order or have been convicted of a violent offense against a partner or a family member, they are ineligible for a firearms license. And again, there's a mandatory revocation, so the CFO must revoke a license within 24 hours when there is reasonable grounds to suspect IPV stalking or when a protection order is issued. And this is a good thing because before, before the bill, the CFO would have to wait until the hearing was completed to be able to revoke the license. And now they can revoke the license immediately and then pursue the hearing and then wait for the outcome through the courts. Again, the firearms must be surrendered to authorities within 24 hours in those cases. Records and reporting, so courts must advise the CFO within 24 hours of protection orders made, varied, or revoked. So again, firearms and lethality. So we know that when there's a history of violence or if there's an impending separation or the couple have separated, that is an increased risk for the potential of IP homicide. So we know that when gun ownership is present or the person owns a firearm, it is actually exacerbates the risk for IPV becoming fatal. And why? It's because the permanent presence of the firearm in the home creates immediate lethal effect. So whether or not the person if it's a premeditated murder or whether or not it's just an impulsive fit of rage and the person is irrational and they reach for the firearm. So obviously this type of weapon can cause lethal effects. And again, how lethal? Well, it's been research has showed it's 5 times more likely than other types of IPV not involving firearms. And the issue that we found in some of the research is that most of the firearms used in these cases were actually legally owned firearms and shotguns. So the relevance to family law. So clients and survivors of IPV are at an increased risk for violence during parenting arrangements. If survivors of IPV are at an increased risk, you have to assume children are at risk as well. Children are often killed in the context of IPV, whether or not they're intervening in an argument or a fight between the couple, whether or not the perpetrator decides to kill the children as an ultimate act of revenge against their partner, or they decide to annihilate the family. So we know that, again, children are at risk, and we need to be mindful of the fact that they are an extension and part of the bigger piece, and their safety needs to be considered as well. So these orders do provide an additional avenue to have firearms and licenses seized to reduce harm during legal processes. So again, if it is immediate imminent danger, then there should be a call to police 911 immediately if there are safety concerns. However, these particular orders actually offer another avenue for victim survivors or anyone who has concerns to pursue this process without getting police involved. Sometimes people might not want police involved, whether or not maybe they've had a bad experience in the past, whether they've had a bad experience with the court process, or they understand the court system where if there is the mandatory charging policy, so if there's a criminal related offense and it's domestic related, the police must lay a charge. So if people have been through these situations or they're aware of this, they might be reluctant to contact police to get them involved, or they're just fearful to have police involved in general. And again, if IPV is suspected, then these orders should be included in the overall safety plan. So the application process, so again, this information is on the Public Safety Canada website, but I'll just walk through this process quickly just so you have an idea of how it works. So anyone can make application to a provincial or territorial court. The judge will hold a hearing. The applicant presents evidence to the court. So evidence can be, they can have statements from a neighbor, friend, anyone who has firsthand knowledge of the safety concerns within that relationship. Any sort of recording, whether it's audio, video, letters, social media posts, financial documents, a diary journal of the events in the relationship, and obviously the testimony and the accounts of the individual themselves. If there's any threats of violence or any attempt of threats of violence or assaults that have occurred, and also police records. And again, the person who is subject to this application is not present. The judge, if they're convinced that there is safety concerns, they will order the 30-day temporary order, and it's made immediately, and steps are also in place to protect the applicant's identity, which I've already mentioned. The person subject to the order is notified, and at that time, their firearms, weapons, and other items are removed, seized by police, or they turn them in, and the firearms license is revoked to up to 30 days. The subject of the order can apply to have the order canceled or lifted for sustenance hunting or in limited circumstances employment. So they can apply to have this order reversed or shortened. If the judge is not convinced that there's safety concerns, then they will not issue the order and the subject is never notified of the hearing. At the judge's discretion, they may decide to set a hearing for a longer term prohibition order. So if there is additional concerns, safety concerns that they have for the victim, they will set this hearing and the firearms will not be returned until the hearing is complete. If a judge decides not to have set this hearing, the firearms will be returned once the emergency prohibition order is canceled or if it expires. If a judge grants the longer term, again, the firearms and license will not be returned. And if they do not grant the longer order term, so the 5-year prohibition, when the emergency prohibition order is canceled, the items will be returned at that time. So finally, I just want to give you another option to make you aware of in relation to getting firearms out of the hands of people that should not have them or pose a risk to themselves or others. So there is something called the public safety search warrants, where someone, if they want to go to the police, again, if it's not an emergency imminent risk, where 911, they should be calling 911 right away, then they can go to the police and they can ask for a public safety search warrant. And this is where the police, they will take information from the complainant and they will take the information and they will apply for a warrant through JP. And if the warrant is granted, then they will have the opportunity to search and seize for firearms, ammunition, crossbow, firearms license, and they will be able to seize those items. And then there will be a further process, but it'll be police driven. So that is another opportunity through the criminal code that is afforded, and there's no criminal code or no criminal offense that needs to be committed. It is purely public safety, so the interest of public safety. If you want to find out more information about this particular public safety search warrants, there is a course. It's called Firearms Seizures in the Interest of Public Safety. You can find it on the Canadian Police Knowledge Network, and it is about a 45-minute e-learning course, and it only costs $33, and it is for anyone. So if you want to find out more about these public safety search warrants, I encourage you to check out that site.
Carolyn, thank you so very much. So thank you for walking us through kind of the new provisions, red and yellow flag laws, and also some automatic provisions within the new legislation, as well as the public safety warrants. So we've got the first two. I'm going to turn it over to Emily now, because of course, Canada is complicated because we have different laws and enforcements federally than we do provincially and territorially. So I'm going to pass it over to you, Emily. My question is, Can you talk about some of the other options that might be available that vary by province and territory?
Yes, thanks again, Katrina, and thank you, Carolyn, for that as well. I am going to speak briefly to options for weapons removal in the context of civil protection orders that vary by region. But before we get into an overview of some of the differences by jurisdiction, we did want to briefly touch on the availability of peace bonds under Section 810 of the Criminal Code as one potential pathway for firearms removal. And of course, just to clarify, all the information I'm going to be providing in this section is some really general legal information, but not legal advice. So, a person may be able to obtain a peace bond in circumstances including where they have reasonable grounds to fear that another person may injure them, their partner, or child, or may cause damage to their property. If a peace bond is ordered, or if the defendant agrees, it can include requirements such as not to have contact with a person or to remain away from a specified location, amongst other possible conditions. Importantly, if a peace bond is issued, the justice must consider whether to include a condition prohibiting the defendant from possessing weapons or firearms. Also include reasons for not adding that condition. Now, unlike red flag law hearings, as Carolyn was discussing, peace bond hearings do typically provide notice to the defendant, who would then also have the opportunity to be present at that hearing. I did also want to highlight some recent changes to the criminal code that came into force in 2025 that provide for a new type of peace bond where a person has a fear of domestic violence. These peace bonds, which you can find out more about under Section 810.03 of the Criminal Code, can actually be extended for up to a 2-year period where the defendant has prior domestic violence related convictions. In addition, these peace bonds can also include provisions like requiring attendance at domestic violence counseling, limiting communication, and can even include electronic monitoring. In these cases, a judge must also similarly consider whether a weapons or firearms prohibition is warranted. So, turning to civil protection orders, most provinces and territories have their own separate civil domestic violence protection order legislation or legislation within family court that allows a person to apply for protections and restrictions in light of risks around safety related to intimate partner violence or family violence. Generally speaking, civil protection orders often have a stream for applications to be made ex parte without notifying the other person and on an emergency or urgent basis. Now, of course, please check the legislation and resources specific to your region as it does vary quite a bit. We'll also share links to each act and some legal information resources as part of the webinar materials for you to check out. Many jurisdictions specifically and explicitly allow for the order, if granted, to include a provision for the surrender and or seizure of weapons or firearms. Again, every jurisdiction varies. So this includes who is eligible to apply for a protection order, the application process, notice requirements, where and when a hearing will be held, the criteria to grant an order, the available relief, and the duration of the order. Jurisdictions also vary in their definitions of what is considered to be either domestic violence, intimate partner violence, or family violence under the legislation. And two, the process for surrender, seizure, or removal of weapons can vary. So for the purpose of today's webinar, I'm just going to briefly review which provinces and territories allow for, or sometimes even require, weapons to be removed when a domestic violence protection order or restraining order is issued. And I should also note that, while protection orders can, of course, serve as important tools in preventing and responding to violence, there are often also concerns raised about factors that may limit their effectiveness. And then lastly, just to note, I'm not going to speak about every single type of protection order available, including, for example, under child protection or family law statutes. I've tried to sort each jurisdiction's approach to firearm or weapons removal when a civil protection order is issued into 4 general categories. First is protection order legislation that requires the surrender or seizure of firearms when the person possesses them. Next are areas that require surrender of weapons or firearms if they were used or threatened to be used. Third, many statutes explicitly allow for the removal of weapons or firearms for certain time periods. And as you can see, this is our largest category. And fourth, there are regions that don't have express provisions in their civil protection order legislation for the surrender or seizure of weapons. And lastly, while Quebec and Ontario don't have specific and separate domestic violence civil protection order legislation, both those provinces have pathways for restraining orders or protection orders that I'll touch on as well. So first is Manitoba, which is the only jurisdiction requiring the surrender of firearms if an order is issued. So in all cases where a protection order is granted and the respondent possesses a firearm, the order must include a surrender of firearms provision. Also notably in Manitoba, justices of the peace must consider several risk factors in determining whether or not to grant a protection order. And this includes the respondent's access to weapons or firearms. Manitoba's act further requires that the chief firearms officer be provided with a copy of the order. I've just included the full provision for reference if anyone wants to look back to the slides and take a read. In the Northwest Territories and the Yukon, their respective acts require the surrender of firearms or weapons if they were used or threatened to be used. In the Northwest Territories, this can be up to 90 days, and in the Yukon, up to 180 days. It is worth noting that both acts can still include a condition for firearm removal as part of the order, even if they weren't used or threatened to be used. It's just not mandatory. And again, I've shared the full provision for anyone interested in taking a read. The largest category includes provinces and territories that explicitly allow for the surrender or seizure of firearms and or weapons as part of the protection order if it's issued. Again, regions vary in how long weapons can be removed for, and some areas allow for the possibility to extend orders while others don't. Some regions, like Nunavut, allow for a protection order to be issued for a longer period, so up to a year in that instance, but might limit the duration for the surrender of weapons to a shorter period, in that case, 90 days. In Nova Scotia, the government recently introduced proposed amendments to actually extend emergency protection orders there for up to a year. They're currently the shortest time period at 30 days. And while British Columbia doesn't actually have separate domestic violence protection order legislation, protection orders from family violence are available under their Family Law Act. Our last category includes statutes that allow for protection orders, but don't include express provisions for the surrender or seizure of weapons. So that includes PEI, Saskatchewan, and also the federal Family Homes on Reserves and Matrimonial Interest or Rights Act. Now, each of these acts do indicate that a protection order may contain any provision necessary for the protection of the person at risk or others. And then lastly, looking to Ontario and Quebec, neither have specific legislation, again, dedicated to domestic violence civil protection. However, in Ontario, restraining orders are available under provincial family law legislation. Neither act in Ontario explicitly provides for the removal of weapons as a condition of the restraining order. Some of you may be interested or have read, but the Law Commission of Ontario recently released a consultation paper on improving protection orders in Ontario. And as part of that consultation, they looked at several decisions on restraining orders where a firearms restriction may have been warranted but wasn't considered. In Quebec, protection orders are provided for in the Code of Civil Procedure. While it too doesn't expressly provide for weapons removal, both the Government of Quebec website as well as the application form both do reference weapons removal as a possible result of such an order. So with that, thank you. And Katrina, I'll hand it back to you.
Yeah, thank you. So I did warn you at the beginning, it gets a little complicated. So we have, you can call the police in emergency situations. We've got civil protections orders that vary. We have peace bonds that are available. We have public safety seizures, and we have all the provisions under Bill C-21. And so, in addition to kind of trying to sort through where and when, I'm going to turn to our next presenter, Heidi, to share some of your thoughts around where Bill C-21 fits in all of this, and what are some of the concerns that you have about the potential impacts or implementation challenges related to these new provisions. What do you want to see incorporated into processes and procedures that really will improve the protection for survivors?
Thank you, Katrina. Okay. I just want to say on the outset that my presentation, which I did partly with Suzanne Zakour, is too long for the 15 minutes we have, but there's good information in there. I'm going to skip over a few slides, but I invite you to read them later on. So I'm just going to skip through the first few slides rather quickly to get to the gist of this presentation, which is to underline the potential risks with respect to the red flag measure specifically. I can't, oh, yes, so sorry, I'm getting used to this. Okay, so a first slide. So just want to say, like, as an first introduction, our group, Petit Se Souvient, alongside National Association of Women in the Law, we've been working on these measures to get these measures for years. And so we were the ones who pushed them and to fought with the MPs to amend them and even to prevent some. And some of you might be surprised about the fact that we're not in agreement with all of them. But let me just say that to begin with, we started out with there are definite problems in the law. Aggressors were falling through the cracks, including where police had knowledge that there was a risk. So that was the main problem, was that there's too much discretion when it comes to potential risks, and women were in danger and died because of this. So what we had before Bill C-21, what we still have is, as was explained previously, is the fact that in Canada there's no right to own guns. If you're afraid that your neighbor or your ex has weapons and and you feel threatened, you can call the police, and it's the police's job to come assess the situation, remove the guns if necessary. And the victim or potential victim and their families have nothing to do. They don't have to go to court or do anything. It's the police's job to protect the public. This has not changed with C-21. So what has essentially changed, so a number of measures related to intimate partner violence. The main one is the discretion is gone. So if the chief firearms officer is aware that there's domestic violence, if there's a protection order that's issued, automatically, there's preventative removal. The question is how long, but the discretion is gone, and that is a game changer across the country. And so we don't have different rules by different police forces, different provinces. However, there's one measure that I'm going to talk about. Obviously, it's the red flag measure, the ex parte measure. You'd be surprised to know, but at least 50 around, anyways, a coalition of women's groups opposed this measure, and it was passed anyways despite this opposition. And the reason why is because of potential risks that are associated with this measure. And here I drew from some of the testimonies of the women's groups in front of the parliamentary committee that was studying Bill C-21. So as I said, first, the responsibility to protect victims or potential victims of intimate partner violence lies with the police. And that's where it should be. That is the most effective way that requires the least intervention or investment or money or procedures by the victims who have enough to worry about. In addition to, needing to go to court and argue with a judge to remove the guns and etc. One of the main risks that was raised by these women's groups is the potential for victim blaming, a well-known phenomenon associated with similar measures where like the burden and responsibility of doing something slowly shifts towards the victims instead of the authorities who are mandated to protect the public. So what they testified is that the red flag measure creates potential conditions that put an unreasonable burden on a victim or survivor to address their safety. When that happens and we create that kind of opening where the survivor is somehow responsible for their safety, the system orients itself in a way that begins to question whether the victim has done everything she could have done based on that interpretation. There are similar other cases that were where it happened, where, for example, the Quebec Association of Women's Shelters said that Section 810 makes it possible for a victim to apply for a peace bond. And the representative said, normally when a person says they fear for their safety, the police should investigate and notify the prosecutor. However, there have been many instances where police officers have told their victims to ask their lawyers to do so. Unfortunately, women have lost their lives in the meantime. All right, continued. So, as I said, the main problem that we see across the country when perpetrators of perpetrators still have access to guns is not because people didn't raise flags. It's because, or notify authorities. It's because the police authorities, in many cases, do not take these complaints seriously. So even like if you look at Nova Scotia, the police were notified numerous times about the abuse and also the fact that the perpetrator had access to weapons. And yet they did nothing serious, meaningful to at least remove the weapons. So the problem is not one of red flags. The problem is one of not taking women's complaints seriously. And the ex parte measure was supposed to maybe politically respond to that, but it has the potential to make things even worse because, as I said, it's up to the victim to go to court and take measures into her own hands. Sorry. What was explained to MPs but not retained is that the ex parte measure, this option, goes against the hard-fought principle of removing any responsibility from a victim with respect to decisions to charge an abuser as it can further endanger the victim. As I said, it is unrealistic to expect victims to have the energy and fortitude, and there's not supposed to be any cost, but obviously having a lawyer is much more effective to go to court while they face all kinds of challenges to just keep their lives on track, their jobs, their kids, and so on. And finally, there's in reality, there's no real anonymity for a victim of intimate partner violence with respect to the ex parte petition to remove the abuser's firearm. An anonymous application that's not made by police to remove an abuser's firearms would inevitably be linked to the person who's seeking protection by removing these guns, and the abuser can very well guess that it's the victim that's behind this procedure. However, that being said, there are cases where this ex parte measure is warranted, as we've mentioned before. If the perpetrator is a police officer, and we know that the rate of domestic violence is higher than average among police officers than the general public, this is an issue. And there are contexts, sure enough, where the victim wouldn't want the police involved. For example, a history of the police not taking their complaint seriously, if the abuser has close ties to police, or if the victim fears the police based on past experiences, especially with respect to Indigenous women and sex workers. So what we recommend, I mean, this is an extra option on top of I would say gold standard in terms of tools. And we have to make sure those tools are well used. We have to improve the use of these tools, but the tool of calling the police and the police doing their job, that is the simplest way. But the red flag law is an extra option that could be useful. So to minimize the risk, it is important for everyone involved with victims of intimate partner violence to expect the police to do its job, to insist that the police do its job, and not allow the police to convince the victim to do the job herself, to go to court herself to have the guns removed. One thing that was added in the bill, which is great if there's a mechanism provincially, is as soon as a chief firearms officer is aware that somebody may be engaged in domestic violence, the chief firearms officer must revoke the license and then investigate and so on. That's great. However, I'm sure in some provinces, it's not the case in Quebec, that there is no process to inform the chief firearms officer, nothing formal, nothing automatic. So if you're a lawyer and you represent a victim, I'm not a lawyer. I assume that if you write a letter to the CFO and alert them that something's, that there's reasonable grounds to believe that somebody is involved in intimate partner violence, then the law applies. So it wouldn't hurt to alert the CFO that somebody, that there's a case, somebody is engaged in intimate partner violence. As I said, push back on police that recommend to victims to proceed with an ex parte application. Why isn't the police doing this? And in order to prevent a shift, a societal shift towards putting the onus on the victims, it's important to document these cases. I don't know who can do this, but whoever has a chance to encourage or ask chief firearms officers, police, and the courts to please monitor, investigate all these ex parte cases and identify why the police didn't do the job and why the victim did. And also to compile this data, because as you know, there's no mandatory record keeping of, as far as I know, of these cases. So, we need to encourage the RCMP and other relevant authorities to find a way to document these ex parte cases, investigate them, and make sure that there's another word that is for shift, but no, that it doesn't deteriorate towards something that is less optimal for public safety. And I think that's it for me. Suzanne, I assume, or I'll send it back to Emily and maybe you can introduce Suzanne.
Yeah, Heidi, thank you. I will. Thank you so much for this presentation. I think it's such important things to think about. And one of the reasons why I think to jump too quickly to, this is how you use this one provision, as opposed to thinking about all the different ways that firearms can and should be removed, is important. And I as you're talking, I'm thinking about what we talked about in terms of public safety seizures and also around calling police and how red flag laws are one tool, but when are they most appropriately used and what the risks are in terms of victim blaming around that. Before I pass on and talk a little bit about what we know about some of the training that might be going on, I wondered if I could invite Suzanne. Is there anything that you want to share in terms of what you've heard so far around some of the debates, maybe in the history, some of your thoughts about how this might fit into these new provisions might fit into the broader context?
Yes, absolutely. One thing I wanted to react to is Emily's explanation of all the protection order legislation in different provinces and how they relate to access to firearms. So one thing that I really want to emphasize is that in the Firearms Act, there is a provision that states that if an individual becomes subject to a protection order, their license will automatically be revoked, and they must deliver their firearms that they have. Why is this important? Is that this will kind of supersede or make more uniform all of these provisions that we've seen in different provinces, meaning that it won't really matter if a province says automatic seizure of firearms or not, discretionary in some cases, and this will last for the duration of the protection order. This provision is in force, but it's not operational. This is a bit weird, and this is for reasons that are not very interesting, but are related to the elections happened and things were not kind of ready on time, and delays, inexplicable delays by the government. But eventually, we hope that this will become operationalize, and Null and Police Souvia and others are advocating for this to cover all protection orders, not just the civil ones, but also the criminal ones. So depending on if we're successful, this will have an impact on the need to use the red flags and other measures that have been discussed in this webinar. And Null is also advocating for some of this to also some modifications to this regime to be introduced as an amendment to Bill C-16, which is currently being considered as a criminal law reform bill, especially with regard to the 810 orders. So I want to flag this for kind of two reasons. First, the state of the law might shift and be aware of when these provisions become operationalized. Second reason, some of the people here might want to get involved in support or brief or advocacy. So you can always reach out to Null or to public safety and kind of mention the importance of these provisions. And the third reason is that under the Firearms Act, there'll be a duty of any court who makes a protection order to notify the chief firearms officer. And so far, we have no idea how this will be done, if it will be done. So I think the lawyers and the professionals in the room might want, especially at the beginning, to make sure if they obtain a protection order that doesn't have firearms conditions associated, to kind of reach out to the chief firearms officer to find out, have they been notified? This is supposed to all happen within 24 hours. And please let us know if you see this working or not working, because this is new law. So that's what I wanted to share on reacting to some of this discussion.
Yeah, so Suzanne, I have another question for you for a second, but before I do that, I wonder, so I'm just gonna, actually Emily is in the background, I think, just gonna flip quickly through some of the slides that we have here at the end that participants will receive that kind of cover some of the different resources by province and territory, some of the things that we've referenced. So I wonder if we can just advance through to the end of the slideshow, kind of just so people have a sense of what's there. And I don't have slide control. And then we will take the slides down so that people have so we can have a bit more of a discussion. So just as people are going to slip through, Suzanne, that's kind of one of the other reasons to be a little bit hesitant, because I feel very hopeful that we might have a regime that isn't quite so confusing from province to province, place to place, time to time, court to court. So I'm really pleased to hear about that advocacy and about maybe having some provisions. But I also hear what you say around kind of this automaticity and timeline. So just before I pass it over, can you talk a little bit about some of your thoughts or concerns about the feasibility of an automatic process and the feasibility of a 24-hour timeline?
So the 24-hour timeline came from our advocacy and our brief. So when we, as Heidi explained, Null provided a lot of amendments and jointly with Police se souvient, and everything in the bill was a bit vague, and we kind of tightened everything to be a bit clearer, and that includes a 24-hour timeline, which was adopted in several places. The courts must notify the CFO. The CFO needs to act also within 24 hours, and then the returner of the guns needs to also be quick. The reason for that is because these are provisions that are meant to intervene at a time of heightened risk, which is separation and litigation. And if there's family litigation, that's also a risk factor. What we've seen, unfortunately, is once the bill is adopted, there's a lot less interest in the ministers and the political to kind of make sure this happens. So we're coming on 3 years of advocating for a regulation to define protection order, which I think should have taken like a few days because the definition was provided by Null and is already in the bill. So it's very not a lot of work. So that's where I think professionals can be obviously advocates for their clients and making sure that even if the system doesn't work as expected, that it's still there's some accountability, and we hope that we'll be able to see if this works or not. And I think if lawyers know that automatically this is communicated, but also we don't know that this is automatically communicated, so maybe I'll communicate it for my client too, so that we can make sure. And sometimes it's good to have some redundancy just to make sure that if something fails, there's kind of a plan B.
Yeah. Thank you so much. Okay, so I'm gonna turn to Carolyn for a second again and then I'm going to take some of the questions that the audience has. But one of the things I know that we talked about as we prepared for this webinar, and actually one of the themes of the conversation that Emily has had with people across the country is really a lack of knowledge about this new provision, but I'll say even myself being in this field for so long, what are all the ins and outs of the various ways to remove firearms and getting all of this straight? I don't think it's something that is well known. There isn't great education out there on all of these things, at least in my perspective. And in particular, I'm turning to you, Carolyn, because people who particularly need to know are justice system actors, and particularly our police. Can you talk a little bit about some of the training that is in place for police around firearms and removal and safety?
Yes, I certainly can. So at the Ontario Police College, so we have the new recruits, so the basic constable training program. And when it comes to domestic violence education and training, they get 6 90-minute modules. The BCT program is 13 weeks. So they do get specific information on the risks of firearms and the potential for lethality and the risks that it poses to victims. There is also a tool that they are also trained on, which is the Domestic Violence Risk Management Report, which is a risk management tool. And within that document, it does have a section where the officer who's going out, and if there's a domestic violence charge laid, they have to fill out this form for court purposes. And in that form, there is a section for firearms to basically cover off, does this person have firearms? Was the firearm license ever revoked? So it does make sure that it cues the patrol officer to make sure that that piece is covered off and what is happening with those firearms. We do have the domestic violence investigative course. So these are officers who are domestic violence specialists in their respective services, and they come and they take an 8-day intensive domestic violence investigative course. There is one 90-minute module specific to firearms related, everything to do about firearms. We talk about the public safety search warrants, peace bonds. We talk about the red flag laws, which is relatively new, and that information is gradually getting out there. The one thing I can say that before the new CSP, so the Community Safety Policing Act, came into force, police services had a choice whether they wanted to send their domestic violence specialist to the Ontario Police College to receive that training. So the Ontario Police College really only touched the services that decided to send their officers to the program. Now that the CSP has come into force as of April 2024, all police services who are doing their own in-house domestic violence training must get accreditation to teach the OPC course. So hopefully this will provide more standardization and that this information will definitely get out throughout the province and through the respective police services.
Okay, and Carolyn, while I have you on an off mute, I guess I will say, the another question that I've heard a number of different times, or concerns I've heard a number of times in talking to survivors or looking at cases, is where somebody has maybe reached out to police, expressed their concern, and the officer or the service doesn't really see this concern as important, or they don't take it seriously, or maybe they say it's serious but then nothing happens. Like, what is your advice to individuals if they're not getting the kind of response that they feel like is warranted from a police service?
Yeah, and I hate to hear that because, we always want police officers to know everything but everything about the law and to keep people safe. And unfortunately, there are police services that are individual officers who don't even know that the public safety search warrant is an option, and that the fact that there doesn't need to be a criminal offense to be that had to happen. It is a process that they can go forward and they can obtain these firearms in the interest of public safety. So recognizing that is an issue. So the OPP, myself, the CFO, have developed that course, the e-learning course that's on the CPKN, that walks through that process. So again, the information as far as public safety search warrants is in the DVI training. So again, if it's only as good as the people that come to the course, but also it's also important for the public to know as well to advocate for themselves. It's just like the healthcare system, right? Sometimes you have to advocate for yourself. There's healthcare professionals that might miss things, and unfortunately, we hate to see that happen. But again, educating yourself that there are these processes in place, and also trying to get out and making sure that these police services are aware of this. And now that there is more of a standardized training with this new CSPA that has come into force, that we're hoping to see a better response.
It makes me think as a service provider within the field. I think, at least in Ontario, I think about all of our coordinating committees or multi-agency committees, and making sure that everybody within that committee is aware, has some information about this, as a way also of just making sure that people know what they should be asking their police, and asking of their police service. I guess that gets me to my next question, and I'm not exactly sure. I'm going to put it out there, and somebody's can maybe answer it. It's about like tracking. What is the way that we are going to be tracking these cases? How many there are? How many ex parte orders there might be? How many different ways or in different instances of firearm removal? I know that the chief firearms officers do actually have an annual report that is public. Is there provisions already in place to include some of this information? Does anybody know?
I can say personally, no, I have not heard of any process in place at this point. And again, I think partly because it is rather new, and like anything, it takes time to get momentum and traction. And obviously recognizing that, yes, this is a deficiency, and yes, we need to follow up on this, and hopefully recognizing that this is an issue, that we will put something in place moving forward. But I will let the other panelists weigh in on that.
Yeah, Heidi, I saw you pop up and Suzanne. Yeah.
Yeah, I can't really answer that in terms of record keeping, but so I shared in the chat by like one brief in both languages regarding all the recommendations that Null and Petit Sissi made following the adoption in the House, even before it was adopted in the Senate. Oh, wait a second. No, maybe I'm wrong. But anyways, close to the adoption, we had a list of recommendations in terms of what needs to be done in terms of education of police, of courts, directive to the CFOs. Like the legislation and the regulations are just one piece of the puzzle in terms of optimizing public safety for women. And a lot needs to be done to make sure that these are effectively implemented. And part of the research showed us that in Quebec, in general, police already do all this stuff. Like of all the provinces, Quebec takes from the research we did, and we talked to the chief firearms officer and to police, that they are doing this stuff. So, for example, as soon as they get a call, as soon as the police goes to the site of a call regarding domestic violence, there's a report. The report's given to the CFO, and the CFO checks if there's guns. But more than that, okay, that's like the minimum that should be done. That is not automatically done in other provinces. But this also triggers like a on-the-spot investigation, because somebody may or may not have a license and still have guns. The police will ask around, will investigate, and see if the perpetrator has access to guns. In Sault Ste. Marie, Angela Sweeney got shot and killed. And her ex then went to kill, well, he injured his former ex and killed his two children. And everybody knew he was a hunter, but he didn't have a license. The police did not do their due diligence to find out whether or not this person had access to guns. This is something, so my answer is that there's at the minimum, there needs to be a process, a protocol for police and CFOs to follow up when there are calls regarding domestic violence. And I'm a volunteer. I have a real job, and Null is also underfunded, and we need help from everybody. We can't push on every province and every CFO and every police force to make sure that these protocols are in place. So please take a look at our brief. It gives good guidance. It explains the process in Quebec. It's linked to everything to all the sources we have. And, we need a grassroots movement to insist that the authorities use these tools properly. And of course, part of that is monitoring how they're used. But if they're not used properly, well, I think things go together. But the first thing to do is to insist that there are protocols that ensure that these new measures, that the public safety potential of these new measures are optimized, are maximized.
Yeah.
And very briefly,
ahead, Suzanne.
I just posted in the Q&A a recent article in Radio-Canada just talking about how they had only found a single case of a red flag order that had been reported. So that's the information that we have. It seems like it's not being used very much.
It's also not well known. It's the new measure. So far, there's been grants given to various local or regional women's groups to talk about the red flag law. We hope they're going to take a more broad approach, but the measure passed, and there's nothing. I think that's the main thing, is that there's some groups that have gotten grants to promote the use. But I think what needs to be done goes way beyond talking about red flag. There's all these other tools and procedures that need to be properly used and implemented.
Yeah, I really appreciate that. I want to get to the kind of few cases, because yes, I know Emily, identified one case. One of our audience members says she's aware of one instance where the red flag law was activated in a high risk family violence case, but the victim's name was printed on the warrant, which resulted in the disclosure to police of the abuser, that the victim had sought this protective measure, which then immediately increased the risk to the victim, because it could be weaponized against that person by the family court, by the abuser. So, um, what this makes me think of again is, what is the process? When is this used? What other processes are in place? That's how I think about it. What are the implementation failures? Other people have any thoughts or reflections on this kind of case where, it's ends up that it's kind of maybe ends up the red flag law increase the risk of harm rather than decrease it. Maybe I'll pass that to Suzanne. Can I do that?
Yeah, one thing as a family law, researcher and advocate is everything is always weaponized against survivors in family court. That is something we see like very, very often. So there's kind of two problems with any protections for victims of family violence is either the victim uses or attempts to use that protection and it's weaponized against her. For example, she'll be labeled as like an alienator. She's just trying to kind of get revenge on her ex. Or the other thing that we see is the abuser uses the whatever was legislated to help victims and claims to be the actual victim of the family violence. So that's a huge risk that is not limited to this context, but I think the important takeaway is it will be really, really important for the lawyers and the professionals to really determine what is the best avenue and what is the safest avenue. And they're kind of two major avenues in the case of firearms. One is if it's a person who's subject to the Firearms Act, it can be a Firearms Act approach. And if it's someone who is not subject to the Firearms Act, so for example, police officers, you can't revoke their firearms license. You need to go through a criminal law avenue to get a prohibition order. And I think this criminal law avenue could be more risky in some circumstances. So that speaks to some of the concerns that were raised. So making sure, making sure that the pros and cons are really well assessed and being aware that this will likely be weaponized if it's known to the family courts, and the difficulty that family lawyers still have in really proving family violence to family courts, because the family courts will not always kind of see it that way.
Well, okay, Suzanne, I'm going to keep you on this topic for a second because I'm imagining, family and yes, so our audience member responded yes, can be malicious intent, misuse of things, just as you described. So if you are a family law lawyer and supporting someone and, now perhaps you've used the help tool and you're thinking about promoting safety and you are worried about somebody's safety. So you talk about kind of making sure that you're aware of the avenues. I guess one of the things I'm also thinking about is there other ways that the family law system can take it out of the hands of the victim so it becomes the family law system's strategy or a response of a lawyer as opposed to a response, an instruction of the victim to go do something. So I think you're talking about that, but maybe help me out a little bit more.
Yeah, I think I understand what you mean. I think it will be different from saying the police should take care of that and to say the lawyers should take care of that, because the lawyer is always instructed by the victim, and the victim, I think most times the victim might know best where the danger is. And one thing that I've kind of wanted to mention is the fear. Fear is probably the greatest indicator of danger, even though we tend to sometimes think in our society that women will exaggerate the fear or will over disclose. The evidence is that survivors tend to under disclose family violence. So you probably most likely don't have the full picture. For example, if there's sexual violence, you probably don't know it. So I think the lawyers need a little bit of awareness that just because you haven't heard that there's family violence in a case doesn't mean there's no family violence. So asking, are there firearms in the home will still be very relevant, because someone who says no family violence doesn't mean there's no family violence. And then kind of being very aware of the feelings of fear, which can be a good indicator. And I think it will be difficult to really like take it out of the hands of the victims in the family law context, but making sure that fear can be disclosed without necessarily having all the pieces together, like asking if there are firearms in the home instead of just asking if there's family violence. Most victims of family violence might not know what it means to be a victim of family violence. So this could be like one strategy to make sure that the lawyer is kind of participating in identifying the risk, even if the victim is not coming to you and saying, oh, actually, I need a protection order and I need the firearm seized. So that could be one way to think about it.
Yeah, thank you. Thank you, Suzanne. As also about that reminding about the balance between, right, like autonomy, being able to have your own control in your own hands. And, somebody described at a meeting not too long ago, they said, I went to the police and then I wasn't driving the car anymore. The police were driving the car, and I wasn't sure that that was really what I wanted. On the other hand, the importance of the system doing its job in terms of public safety and that push and pull between those two perspectives is kind of challenging.
And not putting a burden on or responsibility on the victims. I just want to add an important point is, so I believe that the coercive control bill went through. Is that, I can't remember the number of the bill, but to define domestic violence in a broader
It's
sense.
being studied at committee.
It's still being studied.
It's still a committee. Okay.
Yeah.
But what's relevant here is that in the Firearms Act, there is a definition of coercive control, meaning coercive control applies currently in the case of firearms, in the case of preventative firearm removal. So to complete Suzanne's point is that, domestic violence, in terms of whether or not police need to assess the risks, they need to look at the big picture of domestic violence with all the non-physical, non-violent aspects that count for that need to be that are part of the definition of intimate partner violence. And what's happening with this bill, I don't remember what number it is. Does anybody remember what number it is?
C-16.
C-16 is to ensure that definition is in the criminal code and not just in the Firearms Act.
Yes, this is another whole topic that we could get into in terms of family, criminal, firearms.
The point is for the lawyers is that with Bill C-21, the legislative tools are all there to be potentially used to protect women. A lot more non-discretionary measures that you have to, the CFO needs to know, the protection order needs to be communicated to the CFO. But like and the definition of domestic violence is broad, so that there's huge potential to make a difference with this in the new context.
Yes, and people are commenting that yes, we're also still awaiting, maybe soon not awaiting the Alawalia around the tort of standalone tort of domestic violence. Comments around the importance of education and learning opportunities when things go wrong, some thoughts and concerns around access to firearms and the intersection when that is part of your job, for example, if you're a police officer. So many, many other issues to explore. I'm actually going to turn it over to Carolyn, just in case you have any sort of thoughts as we close up today, Carolyn.
Yeah, thank you, Katrina. I think again, you have to look at the big picture, and this is an overall safety plan for the victim survivor. And this is one facet of it. And if we can remove firearms, however we remove them, until we can develop a more comprehensive safety plan. Usually police are trained to do an immediate safety plan, but then if it's considered a high risk case, then there's more comprehensive safety planning in place. So and it's important to remember that this is just a piece of, the safety planning piece that is so important. And that, again, yes, creating the awareness that firearms uh, increase the risk to the survivor and children significantly. So again, that's all I want to say. It's just part of the overall big picture in the safety plan. Just because the firearm has been temporarily removed for 30 days or what have you, that's just one piece and one component. So, and a tool that we can use. So again, it's just part of an overall safety plan.
And you know what? I'm going to go back to Suzanne for the very last word, as it's because what she has just reminded me of, which is so true, is we so often think about our work to promote safety as being with and about the survivor rather than the person who is causing danger and harm. So, Suzanne.
Yes, 50% of the time, most of you will actually be representing the abuser. And so when we say there are lives at stakes, the law can be used to re-victimize survivors. That is not only something for the survivor's lawyer to hear, but also for the abuser's lawyer to hear. So I think that's really, really important to keep in mind. You should, I think, screen for family violence, even if you're representing the abuser. You might not be able to do the same things, but you need to know and be vigilant on whether you're contributing to perpetuating the system's harm in that case.
Yes, and remember that sort of that sense of desperation, dysregulation, suicidality is a risk factor as well for domestic homicide. And that cases of domestic homicide that involve firearms are disproportionately homicide suicides. So really, it's about safety, and it's a really important thing to keep in mind. So thank you. Thank you, everyone. This has been a really, really important discussion. I very much appreciate being able to have it now as we start to think about how we spread information, not only about this new things, but about the whole of thinking about how we need to respond to firearms, and also about the things that we should keep our eyes open for and advocate for as the final bits of change and regulation go in that are associated with this legislation. Thank you, everyone. And we will see you next time. Bye.
Thanks to you for organizing this.